Okay, hello everyone and welcome to Law 2021 Online's Criminal Law Shape the Debate. My name is Amanda and I work for the Solicitors Group and I will be hosting today's event. In this live session, you can put your questions to Colin and Clive and interact as the information is being delivered. Today's live Q&A is due to last 1 hour and we will cover your pre-submitted and live questions. To the right-hand side, there is a chat function. All questions are submitted in private, so please ask away. If you're watching a replay, the live chat function is disabled, but you may contact the Solicitors Group for further information. A recording of today's live session will be sent out by email within the next few days, so please keep an eye out for this. So moving on to our speakers for today. First of all, we have Colin Beaumont, who is a non-practicing barrister, a duty solicitor for many years and a consultant to a large criminal practice, having formerly been a partner within the same firm. He has been advising on criminal law for 35 years. He has also been involved in teaching the profession for 30 years and has been professionally qualified for more than 37 years, having been called to the bar of the Inner Temple in 1982 and again in October 2017. As part of 2021 Online, Colin's sessions included knife crime prevention orders and knife crime generally, and a 2021 legislation update. Secondly, we have Clive Smith, who has spent over 10 years at the bar practicing in London. Clive undertook mostly, almost exclusively, defence work at all levels, from the magistrates and youth court to the Crown Court and Court of Appeal. Clive's work spanned a wide spectrum involving cases of armed robbery, kidnap, sexual offences and murder. Clive's sessions for Law 2021 Online included Sexual Offences Update 2021 and Bad Character and Hearsay Update 2021. So to kick off, we'll start by addressing some of your pre-submitted questions. First of all, we're going to Colin. So are knife crime prevention orders only available upon complaint by the police at present?
No, I think it's a simple answer to that. The Offensive Weapons Act 2019, we're getting a few commencement orders in relation to this piece of legislation. So do keep an eye on it. I know it went very quiet for a while, it now being 2021. So if you get the chance, and I know you're busy, if you get the chance, do visit the website, legislation.gov.uk, look at the statutory instruments that have been published. I particularly want to refer you, in answer to this question, to Statutory Instrument 2021, number 762. 2021, number 762. That brought in knife crime prevention orders, but only for those courts operating within the Metropolitan Police District. There's going to be a pilot in the Metropolitan Police District for a period of 14 months, commencing on the 5th of July 2021. I suspect that most people will find themselves on the receiving end of a knife crime prevention order because there's been a complaint by the local police to the local magistrates court. But having said that, if you look at that statutory instrument, they are also available as an ancillary order upon conviction applied for by the CPS.
Colin, I think I sent you a brief news article about this recently because I think the CPS had applied for two, hadn't they, upon conviction, and the court in both cases had rejected the application.
That's right, and I was somewhat surprised to learn that. Obviously, we don't know the facts of those particular cases, but it'd be nice to know the stats as to how many of these applications have been made since it came in on the 5th of July.
I don't know, but I think we know the answer to how many have been granted, because I think the answer at the moment is none, isn't it?
Well, not as we see. We don't know the precise situation. It certainly was when you sent me that email.
It was. That was probably about a month or so ago now. So, but as you say, we don't know the current figures, but certainly as of a month ago, yes, I think the CPS has said we'll continue to review these things and we'll keep applying for them, as it were. So we'll see where we go with all that, eh, Colin?
We will. I suspect, as my friend tells me, the court will be unindated. He says that every time. I've stopped correcting him. I think I prefer unindated.
Yeah. My nephew doesn't call cucumbers cucumbers. He calls them cucabumbers, which I think is a far better name as well, Colin.
Cucabumbers.
Yeah. There we are.
Gotta have a place. Gotta have a place in the dictionary.
Got to, hasn't it? My favourite word.
It's got to.
That's it. Everyone listening now, that's officially, we've renamed them.
They are super bumbers.
So moving on to you now, Clive. Moving on. Will defendants have to register on the sex offence register if convicted of voyeurism?
Well, Colin gave a short answer. His question was no. And I'm afraid I can't be quite as short with my answer. And it's a classic lawyer's answer, I'm afraid. It's going to be the it depends answer, isn't it? The first thing is to do really here is to clarify a little bit the question. So there's the offence of voyeurism. We've actually had an amendment, as everybody knows, I'm sure, having watched the my presentation on sexual offences. Obviously, when the Sexual Offences Act of 2003 was passed, within the Act itself, that's section 67, we have the offence of voyeurism. And so that's been on the statute books and it's been in force since, I think, April 2004. However, in terms of update, in terms of where we are now, of course, everybody will have heard of the offence or the issue and problem of what's been colloquially referred to as upskirting by the press. And as a result of that, we've had a new piece of legislation, the Voyeurism Offences Act of 2019. Slightly odd name. I don't know why they needed to add the word offences, because we have the Sexual Offences Act, but we have various acts of Parliament that don't have the word offences in. But anyway, Parliament decided that we needed to have the word offences within the name of the title of this act. So it's the Voyeurism Offences Act 2019. And what that does is it essentially makes the offence of upskirting an offence. So that's where you place recording equipment underneath somebody's clothing to record their genitals, which may or may not be underneath their underwear as well. So that's the addition and change that we've had to the legislation. And so we've now got an additional section 67A of the Sexual Offences Act 2003 as a result of this. So going back to the question, will I have to register? As I said earlier, it will depend. And the answer to that comes from what is subsection 4 of section 67A, which amends Schedule 3 of the Sexual Offences Act 2003 in the sense that it adds to it. So under section 34 and indeed section 34A under Schedule 3, it says that if the offence was committed for the purpose mentioned, namely sexual gratification, and the relevant condition is met, then a person will have to register. So the first thing is that particularly in the magistrates' court, and of course the offence of voyeurism, upskirting under the Act carries a maximum sentence of 2 years imprisonment. So you could find yourself in the Crown Court for that offence, or you could be in the magistrates' court, or of course you could be in the youth court, and I'll come back to the youth court in a moment. But in terms of being convicted, then magistrates or district judges, when giving their reasons, will need to give their reasons in relation to the purpose behind the alleged behind the offence. So do they feel that it was sexually motivated or not? Had it been done for sexual gratification? If they find there was no sexual gratification, so you might, for example, have a 15-year-old in the youth court who was fooling around, and the court might think there was no sexual gratification intended or derived from it, then it might be that condition isn't met. However, if the court does feel there was the purpose behind it was sexual gratification, then the second condition, the relevant condition, must be met. And in terms of the relevant conditions, the first one is that where the offender was under 18, then the offender must be sentenced in respect of the offence to imprisonment for a term of at least 12 months. So in other words, if you're in the youth court and you've got a defendant in the youth court who's being sentenced to a detention training order, then they must have been sentenced, says the legislation, to a term of imprisonment of at least 12 months. Now, importantly, in the youth court, I think, as I mentioned in my presentation, a detention and training order for 12 months is not a term of imprisonment for 12 months, because a detention and training order is exactly that. You spend half in, half out. So actually what a 12-month detention and training order is, it's a 6-month period of detention with a 6-month period of training. So in reality, what that means is you will need to receive, as a youth in the youth court, the maximum sentence of 2 years in order to satisfy the second condition. In other words, you will need to be sentenced to a 24-month detention and training order, because that's the equivalent of a 12-month sentence of imprisonment, in order to get that as a youth in the youth court. And I think Colin and I can both say with some confidence, it's never going to happen. Okay. It's going to be incredibly rare, or in reality, I think it's never going to happen. So as a youth, are you going to have to register on the sex offenders register in a youth court? The answer is no. Okay, probably 999 times out of 1,000, the answer will be no. However, if you're an adult, then it's slightly different, because under subsection 3, it says that in any other case, the relevant condition is that the victim was under 18. Okay, so if you're 18, 19, 20 and your victim is under 18, then that will mean you'll need to register on the sex offenders register if, of course, they found that you did it with the purpose of deriving sexual gratification. The other conditions are that so if the victim is under 18, then that's a tick, you'll need to register. Or the offender in respect to the offence or finding is or has been sentenced to a term of imprisonment. So in other words, as an adult, if you receive a custodial sentence, then you'll have to register under Schedule 3, or where you're detained in hospital, or where you're made the subject of a community sentence of at least 12 months. So again, it's an it depends answer. If you go to prison as someone who's over 18 who did it with the purpose of sexual gratification, then yes. If you receive a hospital order, then yes. If you receive a community order, it's only if that community order is 12 months or more. So there's quite a lot of ifs, buts, and maybes. It's actually a really good question, because the answer isn't very, very straightforward at all. Firstly, you need to look at the offences itself. Then you need to look at the intention behind it. And then you need to look at what the sentence is passed by the court. So as I say, all the answers are there within the Sexual Offences Act. If you look at Section 67, if you look at the Voyeurism Offences Act of 2019, and then if you look at Schedule 3 as well, all of your answers are set out there.
Clive, could I just add one thing? You mentioned the Voyeurism Offences Act creating the offence of recording. But of course, there's two offences created. There's one of using equipment, which might be a mirror. And then, of course, there's a second entirely separate offence of recording. So the legislation actually creates two offences, doesn't it?
Yes, yes. And it supplements what's already there, doesn't it, under Section 67? So voyeurism anyway is an offence. So, for example, if you were looking through somebody's window in their house and they were having sexual intercourse with their partner and they didn't know that you were watching, for example, that's always been an offence, or at least it's been on the statute book since 2004. But as you say, Colin, this is really to target those offences, which generally speaking happen in public, don't they? On escalators, for example, or in supermarkets, we sometimes hear stories about. So yeah, as you say, recording equipment and of course the use of a mirror, any other equipment or device so as to enable you to see under somebody's clothing.
You seem very knowledgeable about where these offences take place, Clive. Worryingly so.
Colin, I just read the newspapers.
If you were my client, I'd be advising at this stage you went no comment.
I'm sure you would, Colin. And I'd probably take that advice, Colin.
Thank you for that, guys. So staying with Clive again for the next question. So where there is a presumption in law in relation to consent, should my client be speaking at the police station?
Well, it's been a long time since I've been anywhere near a police station. In fact, I don't think I've ever been there to advise as counsel, but and certainly I'd defer to Colin on this and his experience of police stations. But from my perspective, in terms of any Crown Court trial, I think there are three broad answers to this in sense of should I be speaking? Because under the law, as I said in my presentation, there are different presumptions. So there are what is known as evidential presumptions, which are of course rebuttable, and then there are conclusive presumptions, which are non-rebuttable. So once the facts are found in certain circumstances, then that's it. So where, for example, there is an evidential presumption, then you may well want to consider speaking at the police station, because that's your first opportunity to rebut that presumption. And what it does, or it may be that you either want to speak at the police station or indeed even put in a pre-prepared statement. And what it does is it at least gets your defence off the ground, hopefully, once you get to court. And it gives you the option, certainly me as counsel, it would give me the option of deciding potentially whether to call my client to give evidence or not. If you've gone no comment in interview, then as counsel, if there's an evidential presumption, then in reality, I've got to put my client in the witness box. Now, in most cases anyway, you'll want to put your client in the witness box to give evidence. But what you're doing really there is giving options. So where there is an evidential presumption, then as I say, I'd certainly on balance suggest it may well be in your interests to speak in those situations. In the other situation, of course, where there is a conclusive presumption, then you may want to speak in interview, but only if you're going to be looking for a caution or something of that nature, because otherwise, if you make admissions in interview, then I'm afraid you have painted yourself into a corner. When you get to court, it may well be, if I'm advising you, you've got nowhere to go if you've made admissions in interview in relation to conclusive presumptions. So, as I say, it's going to depend what type of presumption it is. If it's an evidential one, then I think on balance, you probably want to be talking. If it's a conclusive one, then I'd say almost certainly not. But the only exception to that is potentially where you might be trying to seek a caution at the police station. What would you add to that, Colin? Anything?
Yes, yeah, I don't disagree with that at all. I think these evidential matters, really, the sooner you raise them and rebut them, the better. Of course, the Act is cleverly worded. Such things as if this person was in fear, or if they were the victim of the assault, or if they were detained against their will. You know, there are presumptions that he was not, in fact, consenting. So we better start answering those issues if they're in the complainant's statement. Yep. You know, well, how did she get these black eyes then? It's all very well, commenting today, but do you have anything to say about why she's put in her statement that she's got 2 black eyes? Yep. And if you don't, it's no comment. You're looking to me like a guilty plea.
Yeah.
Great, thank you. So I've got one for you now, Colin. Are mandatory minimum sentences for knife crime only available for adults, or are they available for young offenders as well?
No, they're both courts. In the adult court, it's consideration by the magistrates of a mandatory minimum sentence of 6 months if it's an adult, 18 or over. In the youth court, it's a consideration of a mandatory minimum sentence of 4 months, a 4-month detention and training order, which is where credit for a guilty plea might assist. Because if the courts are thinking in terms of 4 months, if you enter a timely guilty plea, you're entitled to some credit. You don't get your full 1/3. The sentence shall not be reduced below 80% of 4 months, which is good, because anything below 4 months, and you can't get a detention and training order, the minimum detention and training order is 4 months. Slightly different in the adult court, of course, because they're looking at 6 months. And of course, they might decide, yes, you can have your 6 months minus your 20% of 6 months credit for an early guilty plea. Or, as I had once, 6 months. 6 months, Judge, where's the credit? The credit is that I did not commit you for sentence. The offence carries 4 years on indictment.
Yeah.
Not much you can do about that, Clive, I don't think.
Not really, no. The sentencing guideline on credit for guilty pleas is very clear about that, isn't it, Colin? Saying that your credit might be that you're not committed for sentence.
Yeah.
Yeah.
So there you go. You've got the maximum 6 months.
Yeah.
I think you may have just answered this one, Colin, but we'll ask it anyway. So what is the maximum sentence at the Crown Court in relation to possession of knives or threatening someone with a knife?
Yeah, it's rather odd, isn't it? Because for the offence simpliciter of just being in possession of a knife or a bladed article or an offensive weapon, it's 4 years on indictment. And yet for your second strike, 2 strikes possession of an offensive weapon or a bladed article or a knife, again, 4 years on indictment. Threatening someone with a knife, offensive weapon, bladed article, again, 4 years on indictment. The law on indictment draws no distinction between the offence simpliciter of simple possession and 2 strikes possession and possession and threatening someone with it, which I think is rather odd. Clearly, Parliament has taken the view that with 4 years, you've got enough to play with, to cover all the factual circumstances.
Of course, the old sentence used to be 2 years, didn't it, Colin, for simple possession?
I'm going to pass on that one. Was it?
Yeah, I think the maximum is 2 years. And I could see, to your point there, I can see the benefit of that. If you say that for simple possession, the maximum is 2 years,
yeah,
but when you use it to threaten, the maximum is 4 years.
Yeah.
rather than it being an aggravating feature within the offence.
Yeah.
Which is how it's dealt with now.
4 years for everything now if he gets to the Crown Court.
Yep.
That's great, thank you. So, Clive, one for you now. So, must a defendant intend his touching to be sexual to be guilty of sexual assault?
I think common sense would suggest yes, if we go back to first principles of what we always refer to as mens rea and actus reus. What is the mens rea? Well, do you need a sexual intention? And indeed, that's exactly what I think the Crown Court judge felt. So I think it was York Crown Court in the Attorney General's reference case that I dealt with in my notes. The answer to the question is no. The answer to the question is no. The defendant doesn't need to intend his touching to be sexual. And that's what the Court of Appeal said in the Attorney General's reference case. It was a slightly unusual set of facts. A man was on a train going to Newcastle, I think, with his two nieces and nephews, I think. And he got onto the train and the lady was already there and he sat down next to her. And the lady alleged that he turned to her and after a conversation ended up kissing her on the lips. His explanation for this in interview was that some other people on the train had been mocking her and saying that she was fat and ugly, to which he responded that she wasn't ugly and turned around and gave her a kiss on the cheek, on the lips, to show that he didn't think she was ugly. Anyway, she got off the train at Durham and made complaint to the police, and he was then arrested and charged with sexual assault. And at the Crown Court, he was acquitted of sexual assault, but more interesting than that as well, he was actually acquitted of common assault as well, which was put on the indictment as an alternative. So almost asking that same question, does the intention need to be sexual? And so they found him not guilty, not only of the sexual assault, but also of the common assault, i.e. where he didn't need to have a sexual intention, which was interesting considering his admissions, unless they thought it simply came down to what's sometimes referred to as horseplay, effectively. So he was acquitted. But say the Court of Appeal have said, no, you don't need to intend your touching to be sexual in order for it to be sexual assault. That as long as objectively, effectively, somebody might think it was sexual, then that would be sufficient. So, for example, kissing on the lips, you might think is sexual to a degree. And of course, it made no impact to the conviction whatsoever. When the Attorney General refers the point to the Court of Appeal on a point of law such as that, it's purely as a matter of public interest, as a matter of precedent for future cases, rather than you going back and having the conviction overturned. The prosecution don't have a right of appeal against the conviction as such in this country necessarily, other than the slightly different terminatory rulings aspect. But once the jury have acquitted, then there's no appeal against that, unless, of course, you're seeking a retrial. So that's where we are, which is slightly odd. I know you feel uncomfortable about the decision yourself, don't you, Colin? You're not a fan of it.
Well, I can't really square it with the wording of the actual section, which speaks in terms of the intention of the person, doesn't it? When you start putting the intention of the person, you're clearly making it subjective.
Yeah.
It just seems rather odd, but we're going to have to go with it. Obviously, I can see why they've done it, but I'm not sure that it sits easily with the actual wording of, I think it's section 78 or thereabouts.
Yeah, and they draw analogies, don't they, Colin, with other sections within the Sexual Offences Act. And effectively saying that it's consistent with the intention of Parliament in the other sections. And because I think it's silent on a particular point they make reference to, they felt that it was therefore analogous with some of the other sections. But yes, like you, I think I can understand the rationale is actually relatively sound, but I think,
yes,
like you, I feel a little uneasy about the judgment and decision ultimately.
It's just the wording. It's just the wording of the section, which really ought to be altered to reflect what the Court of Appeal have said.
Yeah.
And then we'd all be clear.
Yeah.
Great, thank you. So, Colin, now, one for you. Has the sentencing code changed any aspect of sentencing?
Well, it wasn't meant to. It wasn't meant to. Just a word or two about the sentencing code, if I may. It came into force, the Sentencing Act act, really, but we have to refer to it as the sentencing code. It is an act. Again, can I ask you, if you haven't already done so, can you go on to the website legislation.gov.uk and download the sentencing code? It is a statutory instrument. Relevant if you're convicted on or after the 1st of December 2020. And the purport of the code, obviously, is to codify the existing law in relation to sentencing. So it's in one easily manageable place, and we can easily find it, as opposed to having to look around for the Criminal Justice Act 2003, the Powers of Criminal Court Sentencing Act 2000, the Criminal Justice and Immigration Act 2008. The powers that be have said, look, we've put it in a nice, easily compact format for you, so you'll be able to find it and you'll be a better lawyer once you know the law in relation to sentencing. I'm not sure that one could say that a document containing 420 sections and 29 schedules is an easily manageable document, but at least we know where to find it. Coming back to the question, the purport of the code is to codify the law. It isn't to make new law. But you know, it has made new law in certain areas if you actually go into the minutiae of it. I'll give you an example, just one example. The law always was that if you breached a community penalty that had been given to you, the court could revoke that community penalty and re-sentence you on the original offences, using the powers that they had when you were given the community penalty. That's not what the sentencing code says. The sentencing code says that if you breach a community penalty, the powers of the court are the powers existing on the day when you're sentenced, which aren't necessarily the same powers as the court had when the community sentence was imposed. Interesting. I wonder if that's a nod to section 154 of the Criminal Justice Act 2003. It's never been brought into force, but if ever it is, magistrates will be able to give 12 months for an offence trial either way, rather than 6. So you can imagine the scenario. When you were given the community sentence, the maximum was 6 months, but the section has now been brought into force. When you're being sentenced today, the maximum is 12 months. They can use whatever sentencing powers are available to them today. And it's little things like that that are in the sentencing code, and you read it, you think, that was never the law in the past.
Interestingly, Colin, you and I have had a conversation a while ago, haven't we, about section 154 and about whether or not Parliament will ever bring it into force. I think we're both of the view that in the current climate, with the backlog as it is, if Parliament doesn't bring it into force now, they're never going to bring it into force, are they?
Well, we've waited 18 years for it, haven't we?
Yeah.
Hey? I'm still waiting for certain sections of the Children and Young Persons Act 1969 to come into force. I live in hope. Can I just say for everyone out there, it's lovely to have you with us today. Myself and Clive, we don't get out very much.
Speak for yourself, Colin.
It's true of us all at the minute, I think, isn't it?
Yeah.
a trip to the shop is about as good as it gets at the minute, isn't it?
That's right. Yes. The highlight of the week. Tesco's. Oh, can I come?
You used to run away from it, didn't you? You used to find it.
You did.
Home.
Absolutely. Oh, can I say that other supermarkets are available? Got to be fair and balanced. We don't want any writs. We don't want no writs.
So, Clive, one for you now. Will courts ever pass a whole life order for sexual offences?
No. No, is the short answer to that.
What a case.
Yeah, it's a good read, isn't it, Colin?
Oh, what? It's a horrible read.
Oh, the facts of, the 3 cases involved in them, are all horrific, aren't they?
Horrific.
That they're as bad as they get, aren't they? They really are as bad as they get.
They are as bad as you could possibly get.
Yeah.
The
Hence
depths
why,
of human depravity.
Yeah. Hence why I give the very short answer no. Because effectively that was the question, wasn't it, Colin, that the Attorney General was asking in these questions. Will anybody ever convicted of these really, really, really serious sexual offences ever receive a whole life order? And the Court of Appeal said no. They said, we're going to increase the sentences that you have referred, but we're not going to pass the whole life order. And in essence, you can sum up the reason why they refused to do that in one line. And they said, because we feel that whole life orders should be reserved for the most serious offence on the criminal calendar, namely murder. In reality, though, let's be straight about all of this. I think one of the defendants in these cases ended up with a minimum term of 45 years. That is effectively the rest of his natural life, isn't it, Colin?
Yeah.
That means, although we're not calling it a whole life order, he's not going anywhere, is he? He's never going to see the light of day again.
No.
So for all intents and purposes, they are whole life orders. We're just not calling them that, are we?
Yeah. There are very few prisoners in the English legal system who are subject to whole life orders for murder. Very few.
Yeah.
Very few.
Obviously, Wayne Couzens received a whole life order earlier on this year, didn't he, Colin?
Yes.
But you get less than a handful, less than a handful of them a year probably handed out, don't you?
Yeah. I mean, the European courts have never liked them, have they? Because they consider that everyone should at least have the opportunity for the sentence to be reviewed, albeit after a very, very, very long time.
Yeah. And equally, obviously, there's a lot of public pressure on this at the moment, isn't there, Colin, with cases such as Colin Pitchfork, for example, being released recently and then recalled very soon afterwards. So a lot of scrutiny on the parole board in terms of the way these decisions are carried out anyway.
True.
Okay, so question for Colin now. What is the significance of the offence of strangulation or suffocation being added to section 65A of PACE? Got in brackets here, qualifying offences.
Okay, it's not in force yet, is it? It's one of those offences under the Domestic Abuse Act, section 70, I think. Did the questioner say section 70?
65A.
No. 65A is a qualifying offence. But was the section which creates the offence of strangulation mentioned?
No. Section 70, Colin, I think, is the section that makes consent to serious harm not a defence. So it puts the case of Brown on a statutory footing.
Oh, okay. Well, it's around section 70. It might be 75 then. It's a new offence, isn't it, under the Domestic Abuse Act, strangulation or suffocation. It's at the tail end of the Act, around section 75. In relation to it being added as a qualifying offence within section 65A of PACE, you really need to be aware of that list in section 65A, because it's hugely important in relation to the retention or otherwise of the client's biometric material. We're talking about fingerprints, we're talking about DNA, because if they're charged with one of those offences as a qualifying offence within section 65A, even though you may be acquitted, the mere charge means that the police can keep your DNA and your fingerprints on their database for a period of 3 years. Obviously, if you accept a caution or you're convicted of a qualifying offence within section 65A of PACE, then all of the biometric material and your fingerprints are going to be retained on the database forever. But it's 3 years if you're charged with a qualifying offence, even if the Crown shortly after discontinue the proceedings, they've still got your bits and bobs for 3 years. Clive, I think you were in Dictionary Corner for a moment. Did you find the section?
I did. No, you're absolutely right. It is section 70 is strangulation or suffocation. Section 71 is consent to serious harm for sexual gratification, not a defence. And of course, as you know, Colin, section 71 is in force, but section 70 is not yet in force, is it?
Yeah, that's right. I thought it was 70. Yeah.
And what's the maximum sentence, Colin, for strangulation or suffocation as a standalone offence?
Don't know. Is it
5
years? Is it 5 years?
Yeah.
It's usually, if you don't know, 5 years is a good educated
It
guess.
is. Section 20 GBH, 5 years. Section 47 ABH, 5 years. Strangulation or suffocation, 5 years.
Dangerous driving, Clive. Dangerous driving?
2 years.
Yeah, 2 years. Yeah, that bucks the trend. That does.
It does. Yeah.
Yeah. So there you are. Know your Section 65A list, please, in relation to retention of samples and fingerprints.
Lovely, thank you. So, Clive now. In Midmore, why was a text message sent by a co-defendant who had pleaded guilty admissible against the remaining defendant?
This is a really good question, and one I was asked about a month ago as well by somebody else on another course I was teaching. The case of Midmore we deal with in the presentation. I'll just remind everybody about it. It was the horrible case, the acid attack with the text message sent that said, "This is the one, face melter." And then, of course, they, having bought the acid, they then went and attacked this young lady who they thought had set up the drug deal, where they'd been robbed. As revenge, and they went and threw acid over her face and actually left her blinded in one eye. They received 20 years imprisonment, these two, I think, ultimately. Or the defendant who was convicted after trial did. I think he got a 15-year fixed term and a 5-year extended sentence, extended license on top. So a horrible offence. But yeah, it's a good question. People say, well, hang on, it was the co-defendant who pleaded guilty, who'd sent that text message to the girlfriend saying, "This is the one, face melter." So on what basis was that admissible against the remaining defendant when the co-defendant wasn't on trial with him at the time? He was merely awaiting sentence. The answer is to be found in section 118 of the Criminal Justice Act 2003, which everybody will be familiar with in relation to res gestae evidence. Section 118 of the 2003 Act, of course, preserves various common law exceptions in terms of admissibility. Things like, for example, confessions, expert evidence, bad character, good character, and of course, res gestae, which is the one that most people are familiar with. One of the other little known or indeed little used sections is common enterprise. Common enterprise is an exception to the hearsay rule. And so here in the case of Midmore, in answer to the question, why was that text message sent by a co-defendant admissible against the remaining defendant? Because it was a statement of his intention, and as a matter of law, because they were charged on a joint enterprise basis, it was admissible as a common enterprise. So notwithstanding the fact that the remaining defendant was on trial and he hadn't sent the message, it didn't matter because his friend, and indeed I think it was his half-brother, had sent the text message to his girlfriend. And so it was admissible under that common law exception as common enterprise. So I say, beware that one, the defence advocates. You might think, oh, it's all right, the co-defendant said that. That won't damage or hurt me. And of course, he's not here and he won't be giving evidence, etc., etc. But as I say, a very smart prosecutor in that case. She rightly adduced that evidence at trial, which undoubtedly went a significant way to seeing him be convicted as well.
So there was no significance in the fact that a guilty plea had been entered and they were no longer co-defendants. That wasn't the legal issue at all, was it?
No, none at all. No, this wasn't a Smith position, Colin. This case of Smith from 2007 and under Section 74 of PACE, where you might apply to put in the conviction of a co-accused.
Yes.
No, this wasn't a Smith situation,
No.
Because he wasn't saying that the offence hadn't happened or that it was a different offence. He was simply saying, I wasn't there at the time and I wasn't party to the acid attack. That was his defence. Mm.
Not a relative, I trust. Smith.
None of mine. Colin, you're traducing my character today, aren't you? You said you didn't want any writs. You'll be receiving one from me if you carry on like this.
Oh dear. I must be kinder to barristers.
Well, you're a barrister again now, Colin.
I know. We're very litigious, aren't we? We're very litigious.
Question for Colin now. So, is it the case that any offender given 7 years or more at the Crown Court for an offence now has to serve 2/3 of the sentence before being released?
And the answer is no, fortunately. It's not every offender, but you've really got to be on your mettle if you're at the Crown Court now, because certain offenders, they're not being sentenced under the dangerous offender provisions. They're just being given a sentence of 7 years or more. I believe the alteration in the law came on the 1st of April last year, whereby certain offenders now who get 7 years or more as a determinate sentence, they're no longer automatically released at the halfway stage. They have to serve 2/3 before being released. And these are specific offenders who have been sentenced for an offence that was formally mentioned on Schedule 15 of the Criminal Justice Act 2003, but has now become Schedule 18 of the Sentencing Code. I'm sure you're familiar with your Schedule 15 specified offences of violence and specified offences of a sexual nature. It's got to be an offence falling within what is now Schedule 18, and it's got to be not only one of those specified offences, but it must be a specified offence that would otherwise carry life. So, rape would be a good example. If you're given 12 years for rape now, you're not going to be out at the 6-year stage. You're going to have to serve 8, 2/3 of 12 years. Ditto for grievous bodily harm with intent. But the important point to bear in mind is it's got to be one of those Schedule 18 offences that would otherwise carry life. There's a lot of offences on that schedule that don't carry anything like life, whereby the 7-year rule won't apply.
Colin, there was an interesting case, wasn't there, just back in April, May time, because there, as a result of the pandemic, there were some defendants who were due to be sentenced at the end of March,
yes,
but the trial had to be adjourned due to the pandemic, and they ended up being sentenced in April instead.
Yes.
And they received more than 7 years imprisonment, didn't they? Just because of that short time delay, they will now end up serving 2/3 of their sentence instead of 1/2. And they went to the Court of Appeal and stamped their feet and said, this isn't fair.
Yes.
And the Court of Appeal said, we know, but that's what Parliament have done. Tough.
That's right. That's right. The Court of Appeal said, whilst we acknowledge that the delay was no fault of the defendants, the legislation had changed. Parliament had changed it on the 1st of April, and we can do nothing about it.
Yeah.
Harsh.
Very harsh. Yeah.
There was a case I was reading the other day whereby a chap was given 6 years and 10 months for rape. Interesting that. 6 years and 10 months. So clearly, Crown Court judges know about the 7-year rule, don't they? Yeah. The bad news for this particular defendant, given 6 years, 10 months, was that the Attorney General thought it was unduly lenient, took the matter to the Court of Appeal. Court of Appeal said, we think it is unduly lenient, 14 years. Oh. And the Court of Appeal said, notwithstanding, we appreciate fully that he would have to serve 2/3 of 14 years rather than a half of 6 years, 10 months.
Ouch. Colin, there was a judge in central London, I shan't say where, some years ago, that in relation to qualifying curfews, of course, as you and I both know, you have to be on a 9-hour electronic curfew in order for it to qualify. Yes. He was giving defendants on bail, he was giving them an 8-hour curfew. So it didn't qualify. Yes. So you go back on the next occasion in front of another judge, and the judge would adjourn the case, say bail on the same conditions as before, and you stand up and say, actually, Your Honour, could I address you on the curfew? Could I ask you to extend the curfew? And the judge would look at you as if you had two heads and say, sorry, Mr. Smith, you want me to make your client's curfew more onerous?
Yes, please.
And I say, yes, please, because at the moment it doesn't count. And then they would ask, and which judge is it that's doing this? And you tell them, and they just give a knowing smile.
Court of Appeal decision I was reading the other day, Clive, this particular person had been given a sentence that was so unduly lenient, it wasn't even custody. It wasn't even custody. Wow. Get to the Court of Appeal. Court of Appeal said, no, we're not having that. 3 years. And they said to counsel, could you address us, please, on the police station nearest to your client's address, the police station at which you'll have to surrender tonight? So they're asking counsel for his local police station.
I've been in exactly that situation in the Court of Appeal, Colin. And my client was sat at the front of the court, and it's like the elephant in the room. They say, well, where can your client surrender? And I said, well, he's at the front. Normally you just take him down to the cells straight away.
Yes.
And so fortunately, I had very experienced Treasury counsel prosecuting me, and they sort of sidled along the row and just said, ask if he can surrender at his local police station. So I did. And he had to turn up there at 6 o'clock on Thursday and surrender himself. Yes. Very American, isn't it, Colin? You know, when you get sentenced and you surrender to a prison 28 days later. So, yeah, Attorney General's references, Colin, I've dealt with one, and it was very, very odd and unusual. And I did exactly that. Went from a non-custodial sentence, a suspended sentence, in fact, to 3 years custody.
And just finally, talking of having people in court, I knew a justice's clerk once who used to do the fine default court. He'd get all the fine defaulters out of the gallery, sit them all out of the foyer, sit them all in the public gallery, and then he'd stand up, he'd say, good afternoon, your worships. I'm the justice's clerk, and I appear to prosecute. and then sat down. He said, you wouldn't believe the phone calls that were made and the money that came in.
Yeah. The enforcer, they probably called him, didn't they, Colin?
Absolutely. He'd have them all in the public gallery. Imagine doing that, addressing the magistrate, saying, and I appear to prosecute, and then sit down in the clerk's chair. Amanda, we digress. Sorry. I just forget work, Clive. Sorry.
We do. Having far too much fun.
Clive, coming to you now. If I raise self-defense, will my bad character automatically become admissible?
No, I think is the short answer, but I think it's worth developing that answer a little bit. If you raise self-defense, then you're perfectly entitled to raise the issue of self-defense without your character going in. But it will depend how you raise self-defense. So, for example, if you were asked in police station interview, did you assault the complainant, and you say, yes, I did, I was simply defending myself, then I think that would probably be fine. But if you were to say, yes, I did, they hit me first, and therefore I was defending myself, then I think you've probably put your character in, because you are making an attack on their character. You are saying that they have shown a propensity to be violent. They were the one who launched the attack on you. They were the aggressor. And of course, the courts have consistently said that if you're going to make those sorts of attacks on somebody's character, then the court's entitled to know the character of the person making that attack and weigh it all in the balance. So I think you need to be, I say you, of course, as legal advisors to our clients, but clients, defendants need to be very careful about how they're going to raise these things. And I know that there are many, many good lawyers out there who will invariably advise their clients before going into interview about how they might want to express themselves. Of course, you can't coach them and counsel them and tell them what to say, but you can simply advise them. And we all know that defendants, or indeed suspects as they are at the police station at that stage, will go into interview and, of course, ignore everything you've told them. You may have told them to go no comment, and they'll sit there and start answering some questions, and you'll try to gently kick them under the table or something else. Or you might have, I don't know, if you're doing it virtually, you might start scratching your head very vigorously to distract them. I don't know. But as I say, you can only give this advice, and it's up to them whether or not they follow. So as I say, it will depend. If you raise self-defense, then no, your character won't go in automatically. I was reading an interesting case a while ago, Colin, that I came across in Archbold. And I think it's the case of Hunter. It's an old case now and doesn't deal specifically with the issue. But certainly Peter Rook, who used to be a judge at the Old Bailey and certainly one of the leading experts in terms of sexual offences, he wrote a book called Rook on Sexual Offences, or as a QC I know calls it Rookie on Nookie, she refers to his book as. And he wrote a book on sexual offences, and very much his view that in a rape case, for example, if you were to raise the issue of consent and say that the complainant was consenting, would you be making an attack on another person's character? And I think his view is very clear, and the answer would be yes, you would be. So though you're not explicitly saying she's lying, you are implicitly saying she, or indeed he, is lying, because you're saying, well, they were actually consenting when they've actually reported to the police that they weren't consenting.
A couple of interesting cases in relation to assault, one of which is Lamaletti. If my memory serves me well, Lamaletti and another person were minding their own business, according to Lamaletti, when the aggressors came over the road to them and started a vicious, unprovoked attack upon them. And the judge said that whilst it was a fine dividing line, on those facts, he took the view that Lamaletti was attacking the character of other people involved in the proceedings by saying that they deliberately crossed the road and, of course, had conducted an unprovoked attack upon Lamaletti and his friend. Obviously, the other people were the complainants and the prosecution witnesses in the case, and their story, their account was very different. But can you see the point that saying, oh, well, I was minding my own business and this other person came across the road and conducted a completely unprovoked attack on me, and I was therefore defending myself? That's tantamount to an attack, isn't it, upon the character of the other person involved in the proceedings?
Yeah, I think that's certainly the case that I refer to in the notes, Colin. I think it was a taxi driver, wasn't he? Mr. Lamaletti was out with a lady on a date one evening. They got out of the taxi,
yes,
and left. And as you say, then the suggestion was that the taxi driver came over the road and launched this unprovoked attack. Yes. But I think the taxi driver's account was they'd run off without paying, or they'd left, yes, made off without paying. Yes. So as you say, it's the difference between robustly stating your defence, isn't it? Yeah. And aggressively attacking someone else's character and saying they were the instigator in all of this.
Yeah. So, and the other case in the Court of Appeal that I was reading was the case of Kidd, K-I-D-D, in which the Court of Appeal said, again, it was a fine point, but on the facts of the case, they didn't think that Kidd had been attacking the character of the other person merely by arguing self-defense.
Yeah.
Okay, so see how we get. This might be the last question, or we might squeeze one in after. We shall see on our time. So one for Colin. What is the law now in relation to the possession of certain offensive weapons in private?
Ooh, bear with me, because in order to answer this, I'm going to have to grab a statutory instrument. Hold on.
Word you never thought you'd say, did you, Colin?
Indeed. Indeed, absolutely.
While Colin's doing that, there used to be a band in Parliament, I think, made up of a few MPs and a couple of people who worked at the Houses of Parliament, and the band was called the Statutory Instruments.
The Statutory Instruments. Wonderful. Thank you, Clive, for filling in there. I found it. It is Statutory Instrument 2021, number 819. Statutory Instrument 2021, number 819. It's a riveting read. It's the Offensive Weapons Act 2019, in brackets, commencement number 1, close brackets, regulations of 2021. Came into force 14th of July this year. And if you look at the explanatory note at the end of this particular statutory instrument, it says that certain sections of the Offensive Weapons Act have now been brought into force. Those sections prohibit the possession of offensive weapons in private. Weapons to which Section 141 of the Criminal Justice Act 1988 apply. So have a look at Section 141. This is a real issue. Imagine you're at the police station advising a client. They've done a drug search, a warrant, and lo and behold, they've found various things of an offensive nature, offensive weapons, which you're now no longer allowed to keep, even in private. Obviously, it's been the law for many years, hasn't it, that you've not been allowed to have these offensive weapons in public. That's been the law since 1953. Now, apparently, you can't even have them for your own interest in private. Clive, were you looking something up there?
I was just looking to see who was in the statutory instruments, Colin.
Statutory Instrument 2021, number 819.
So we are going to squeeze one last question in, and this one's for Yeah, see, we've managed it. This one's for Clive. So, at a retrial, will rulings on character and hearsay remain as at the original trial?
It's a good question, and I'm not sure we've ever had any. Colin's got his eyes aghast. Who knows?
I'm glad this one came to your lap.
Who knows, says Colin, and quite frankly, who knows is probably my answer. I suppose that there are two types of retrial, I suppose, in the sense that you may have been convicted and then gone to the Court of Appeal and had, if you're very lucky, your conviction overturned and then gone back for a retrial. In that scenario, what tends to happen, I say what tends to happen, what will happen is that you will have a different trial judge to the original trial judge. So what the Court of Appeal are usually saying is that something went wrong with the trial. And as a matter of simple practice, I think the original trial judge wouldn't in that scenario then hear the retrial, of course, for risk of bias or fear that something else might go wrong next time round. It's usually that a fresh pair of eyes will be required at the retrial. Equally, what might have happened is you might have had a hung jury. And so you might have had an original trial, you might have had a hung jury, and then you might have a retrial. Now, that retrial is most likely in that scenario to be in front of the same judge for obvious reasons, for continuity purposes. And in that scenario, I think 99 times out of 100, the judge is going to stand by his or her original rulings at the first trial. So, there's absolutely no reason why they would, or no good reason why they would generally change them. Unless, of course, there's been a change in circumstance. There's been some fresh evidence come to light, or there might be a witness who's no longer available, etc. And so the judge's rulings might have had to change as a result. But as a general rule, I think most judges see that it's good practice, at least, to stand by their original ruling. So if you are having a retrial as a result of a hung jury, for example, and you're in front of the same judge, then I think most judges would simply say, in terms of points of law argued before, my decision's not going to change unless you say there's some fresh evidence that I should take into account. The first scenario that I gave, where, for example, the Court of Appeal has overturned your conviction and you do have a new trial in front of a new judge, then I think you have to say quite generally that all bets are off, all bets are off the table, really, in the sense that you've got a fresh judge, you've got a fresh pair of eyes, and whilst they may well feel bound by some of the decisions of the previous judge, they may well come to a different decision, particularly, of course, on the point that you may have gone to the Court of Appeal on. And equally, of course, you might well have some very, very good guidance then from the Court of Appeal on the point on which you had your conviction overturned. I think that the case that I gave as an example in the notes, in the presentation in relation to bad character, that was a case where there had been a retrial. I don't think the case had gone to the Court of Appeal and ended up going in front of a different judge. And I think it was a retired High Court judge who'd come in to hear the case. It was a very, very serious offence of child neglect, all too chillingly similar to the sad case we heard this week or the end of last week in the press. And so there was a new judge brought in, and he, in that case, said, I do not consider myself bound. And of course, there's no issue of precedent in terms of one court or one judge being able to bind another, certainly in the Crown Court, at least anyway. But most judges will tend to follow what the judge has done before them, unless there is a good reason to change their mind. Here, of course, the judge felt that perhaps the judge had made a decision with which he disagreed and so changed his mind. So not a very clear answer from me, because I think the short answer is no, they won't remain as at the original trial. But I think in the majority of cases, they probably will.
I agree.
But if they don't, can you do much about it? Not really. You can simply argue about it in front of the Court of Appeal. And the Court of Appeal, of course, the Court of Appeal have said in several rulings at times, they've said that whilst the trial judge may have come to this particular decision on this point, a decision which we may not have come to, that doesn't mean it's wrong. As we all know, it's a very high threshold in saying whether or not the judge's decision was wrong. Ultimately, it's going to be a decision as to whether or not it was Wednesbury unreasonable. And the Court of Appeal have said that we might disagree with the judge, but that doesn't mean it was Wednesbury unreasonable, and therefore give rise to a ground of appeal.
That's great, thank you. So, unfortunately, that is all we have time for today. Thank you for attending Law 2021 Online's Criminal Law Shape the Debate, hosted by the Solicitors Group. Thank you to our expert speakers today, Colin Beaumont and Clive Smith. Don't forget to join the Solicitors Group Law 2021 online community on LinkedIn to continue the debate after the live session and be included in exclusive offers for future events. As mentioned at the beginning of beginning of the record of today's session. A recording of today's live Q&A will be sent out by email within 48 hours. There is still time to watch the pre-recorded content. Your expiry date will be displayed next to the webinar. Feedback forms for the event will be sent out when the event closes. By completing this, you will receive your CPD certificate. Please don't forget to visit the online exhibition at www.thesolicitorsgroup.co.uk. By visiting the exhibition, you can access a free 1-hour CPD webinar from our webinar learning catalogue worth £35 plus VAT. So what's left for me is to say thank you again. Thank you to our speakers, and we hope you have a great day.
Yes, thank you very much. Goodbye.